In this lesson, we're going to be covering Chapter 14's content, which was on media freedom, regulation, and ethics. In this lesson, there are 3 key points. First, the First Amendment. Second, social responsibility theory. And third, media industry ethics. We're going to be completing this lesson in a couple of parts. First, I'm going to cover the First Amendment and social responsibility theory. Then we're going to take a break for you to complete an activity about SRT. Then I'll be discussing media industry ethics. After that, you're going to be asked to complete 2 activities related to that topic. So the first topic for today is the First Amendment. Of course, you're already familiar with the First Amendment because we've talked about it before. As a reminder, it says in part, Congress shall make no law abridging the freedom of speech or of the press. Of course, the First Amendment includes more protections than this, but for our purposes, the most important bit is that Congress shall make no law abridging the freedom of speech or of the press. So, what you need to know about the First Amendment is that there are multiple approaches to interpreting the First Amendment, 2 in particular that we're going to discuss here. The first one is the absolutist position. The absolutist position says no law means no law. So period, end of story. There should be no restriction on freedom of speech or of the press. So the absolutist position, no law means no law. Period, end of story. The other approach to the First Amendment is the ad hoc balancing of interests approach. This approach says that factors should be weighed in determining the amount of freedom granted because of competing liberties. So essentially what the ad hoc balancing of interest approach says is that you can have freedom of speech to the extent that it doesn't override some other important freedom that you've been granted. So the Constitution grants us many freedoms, not just freedom of speech, but other rights as well. So the ad hoc balancing of interests approach acknowledges that and says that you should have freedom of speech, but only to the extent that it doesn't infringe on some other liberty that at the time is more important. So here's an example. The Constitution grants you freedom of speech, but it also grants you the right to a fair trial. In some circumstances, these could compete. So imagine a case that the public's really interested in that a news outlet wants to cover. So maybe they want to be right in the courtroom. So that would be freedom of speech. The press has the right to come into the courtroom. But the person who's on trial also has the right to a fair trial. What if the news cameras being in the courtroom is interfering with the trial, is interfering with the jury by providing distraction, and thus is undermining the right to a fair trial? The ad hoc balancing of interest approach says that we should weigh free speech versus fair trial in that particular circumstance. And so maybe ultimately what's determined is that it's more important for that person to have a fair trial, and so they're not going to allow the courtroom to become a circus with news cameras everywhere. Maybe they're only going to allow journalists in taking notes and not cameras, for example. So ultimately, that's just one example of how different liberties might come into competition, and thus this approach would come to bear. That ultimately, freedom of speech might be restricted to the extent that it grants another liberty that is determined to be more important at the time. So there are some restrictions on freedom of the speech, and more particularly, it's the Supreme Court that provides definition and refinement of the First Amendment. They've done this over time through various cases. So it's not even just like over time, like, oh, long time ago, history. They're still doing this actively today. The Supreme Court will pick up a case that is about free speech and freedom of the press, and by creating a decision on that case, they then are providing a refinement to the definitions and to our understanding and interpretation of the First Amendment. So what to date have they defined and refined in terms of our understanding of free speech. The first thing that they've defined is, what do we mean by no law? So when it says Congress shall make no law, what do we mean? And the Supreme Court has determined that no law means no statutes, laws, administrative regulations, executive and court orders, or ordinances from government, regardless of locale. So no laws plus no executive, that means presidential orders or governor orders, or court orders. So all branches of government, legislative, executive, and judicial branches. And it also means regardless of locale. So that refers to no federal government, state government, or local government should restrict freedom of speech. So no law is pretty all-encompassing. It's all levels of government as well as all branches of government. The second term that they've defined and refined is what we mean by the press. Now, when we say the press, what comes to mind most readily for most people is news and journalists. But that's not how the Supreme Court defines the press. They have defined the press as all forms of media, even entertainment media and advertising. So all forms of speech are protected under the First Amendment, all forms of media. That means video games, that means magazines, that means movies, that means television, and all of the ads that appear in all of those places. So the press involves all forms of media. Then the third definition that they have provided is for abridgment. So the First Amendment says abridging the freedom of speech or of the press. So abridgment, today's interpretation, suggests that restrictions on time, place, and manner of expression unrelated to content are allowed. So what cannot be abridged is specific messages, specific content. What can be restricted is time, place, and manner of expression. So think of it this way. You can have, for example, an ordinance that restricts noise at a particular level in a residential neighborhood, right? So you can't have super loud music blasting in the middle of the night, right? It doesn't matter what it is that music's about. You just can't have noise. That's allowed. So a restriction on time, place, or manner of expression, like a noise ordinance, that's allowed. As long as it's not about the content, as long as it doesn't matter what you're saying. It's just about when, where, and how you're saying it. So abridgment refers to the restriction on content, not the restriction on time, place, or manner of expression. So within the definition that the Supreme Court is using today, they are allowing specific restrictions on freedom of speech. So using the definitions and refinement that the Supreme Court has set precedent for, ultimately, freedom of expression is not absolute. It's not that anyone can say anything at any time or place. There's a level of protection that is one of degree. So specific forms of speech are not protected at all. Other forms of speech are protected to some degree. Some forms of speech are completely protected. So it's a matter of degree. So there are some related concepts that I want you to be familiar with regarding restriction of freedom of speech. The first one is prior restraint. Prior restraint refers to the power of the government to prevent publication. So the government does have this prior restraint ability, the ability to step in even before something is published, to be essentially proactive in restricting speech. They do this very, very rarely. So prior restraint exists, but it is very, very rarely used. So it's unlikely for the government to step in before something is published, though they can. The second concept related to restriction of freedom of speech is clear and present danger. This is a form of speech that is not protected under the First Amendment. So you do not have the right, essentially, to pose a clear and present danger to the public. This is why you can't go into a crowded theater and yell fire if there is no fire, because you're creating a threat to public safety. You can't do that. You cannot pose a clear and present danger. That's not protected under the First Amendment. Other restrictions on freedom of speech include libel and slander restrictions. Libel is the false or malicious publication of material that damages a person's reputation. Similar but different, slander is the oral or spoken defamation of a person's character. So the key difference is libel is published, slander is spoken. Publication in terms of libel is broadly construed. So it's not just like the physical publication. It could be related to publishing something online, for example. So in either case, it's focused on damaging a person's reputation or defaming their character, really similar types of things there. Now, the key thing to understand regarding libel and slander is it isn't libel or slander if it's true. So if a publication puts out a story that makes someone look bad, but it's based on factual evidence, then it can't be libel or slander. So a publication can't be held accountable to damaging someone's reputation if that's been done based on things that were factual. So it isn't libel or slander if it's true. So these are two, again, restrictions on freedom of speech, libel and slander. Another restriction on freedom of speech is obscenity. So there is no protection for obscenity. What is obscenity? It's something that's designed primarily to stimulate or appeal to sexual interests, that has no artistic value, and violates contemporary community standards. Now, I've put "and" in bold here because in order to be considered obscene, something has to meet all three criteria. It's designed to primarily to stimulate or appeal to sexual interests, and has no artistic value, and violates contemporary community standards. Now, obscenity is another item that is very rarely used. So it is unlikely for something to be challenged under the law of obscenity. Why? Because of the second and third criteria. The first criteria is relatively easily met. There's lots of material available in America that's designed primarily to stimulate or appeal to sexual interests. Porn. So all porn is that. It's used primarily to stimulate or appeal to sexual interest. However, it's the second and third criteria that are harder to grapple with. So first of all, it has to have no artistic value. Well, this is subjective, right? What one person deems artistic, another person deems not, right? So whether or not something has artistic value is really going to be a subjective call. And then the third one is even harder to grapple with, violating contemporary community standards. Because what are our contemporary community standards? It varies from person to person, right? So one person's moral judgment regarding a piece of material might be different from another person's. One person might watch Game of Thrones and being like, oh yeah, that's totally cool. Another person might watch Game of Thrones and being like, that's totally inappropriate. So it varies from person to person and from community to community. And that's why it's very difficult for something to actually be determined to be obscene. And it's also why then rarely is something challenged under this law. What would be obscene? Well, an example of something that would be obscene would be child pornography. That's something we've decided, no, that's obscene. That is not protected under the First Amendment. That violates our contemporary community standards. So that would be an example of something that would be considered obscene. So now we're going to turn to some other issues of freedom and responsibility. These are somewhat related to the First Amendment, but they are not particular to protection of speech. Rather, they have more to do with the responsibility of the press in this environment. So the first issue is what's called deregulation. Deregulation is the idea that in today's environment, there are very few restrictions on media content, and this is in fact the case. So there's very few restrictions on media content, on what it is that media can put out. Now, remember that many of our media industries use rating systems to rate content. This is appropriate for this audience, but that doesn't mean that the content can't be published. It's just that it's published with a particular rating on it. So what restrictions are there? Well, one item that's restricted is indecency. Indecency is the depiction of sexual or excretory activities in a way that is offensive. So that's the definition. And indecency is prohibited on broadcast TV and radio between 6 a.m. and 10 p.m. So it's very specifically about broadcast TV and radio. Remember that this is what's put over the air. So broadcast TV really, for the most part, is just ABC, CBS, NBC, Fox. There are a few others in specific markets, but those 4 channels in particular are broadcast TV. And radio, what's put over the air that you could get just with any radio tuner, not satellite radio, or radio that's broadcast over the internet. So it's prohibited to broadcast TV and radio between the hours of 6 a.m. and 10 p.m. because that's when children are most likely to be watching or listening. So there is this restriction of indecency, sexual or excretory activities. There's also a restriction on profanity. Profanity includes grossly offensive language that is considered a public nuisance, essentially swearing. So what constitutes grossly offensive has shifted over time. So we allow language today that we didn't used to allow, but there is some language that is just considered grossly offensive. The F word counts as that. And this, again, is prohibited on broadcast TV and radio between 6 a.m. and 10 p.m. So you can't say the F word on broadcast TV and radio. It's all over cable and it's all over satellite radio. But it's only restricted during the hours of 6 a.m. to 10 p.m. So profanity is restricted, particular to broadcast TV and radio in those hours. Other issues of freedom and responsibility. The final one is copyright. So copyright identifies and grants ownership of a given piece of expression. So a copyright is something that identifies who made this thing, who wrote it, who produced it, and grants ownership. So you legally own a given piece of expression. Copyright is granted for the lifetime of the creator plus 70 years. And then the material goes into the public domain. So the public domain is something that is freely used material. An example of something in the public domain would be like the song Happy Birthday. So it's available to anyone for use for free because it's in the public domain. The copyright has long since passed. So copyright identifies and grants ownership for the lifetime of the creator plus 70 years. Now, why is copyright important? Because using copyrighted material generally involves a royalty, that's a fee paid to the owner, except in cases of fair use. So if a song has a copyright on it, you can't put it into your video unless you have paid the royalty, paid the fee to the person who owns it, generally speaking. The exception to that is fair use. Fair use is a particular set of guidelines that includes one of the major ones, use for education. So this is why, like, I can show you movies in class that are copyrighted without paying a fee. It's because it's used for educational purposes. So copyright is important because it ultimately protects people who make different pieces of media. Okay, that is it for our topic of the First Amendment. Our second topic for this lesson is social responsibility theory. Social responsibility theory is what's called a normative theory. A normative theory explains how media should ideally operate in a given system of social values. So a normative theory is all about how media should operate, not a description of a media system, but rather dictating this is how it should be. And it's in light of a given system of social values, because we can't say that there's one ideal across every society. It depends on what that society thinks is important. So a normative theory is specific to a given system of social values. Now, SRT, or social responsibility theory, in particular, says that media must remain free of government control, but in exchange, media must serve the public. So essentially acknowledging freedom of the press, that media must remain free of government control, but in exchange, they really should have serving the public as their foremost goal. So the media system should all be all about serving the public. Now, SRT is the standard against which U.S. media should be judged. So this is the ideal for the U.S. media system. It doesn't apply to other systems because other systems may have different social values. This is based on our First Amendment, as well as what we feel as a society our media should be responsible for. So this is the standard against which U.S. media should be judged. Now, SRT has been used to formulate a set of core assumptions. And these core assumptions appear in your textbook. They are reproduced here in your slide and also in the slides that were available for download. So what we're going to do at this point is I want you to think through these core assumptions of social responsibility theory as they relate to what you know about the U.S. media system. So next we have an activity that gives you the opportunity to reflect on these and how our media system is measuring up in terms of these core assumptions. So when you're ready, hit next page. These will appear again on the activity, the core assumptions, and ask you to reflect on them.